Hello, everyone, and welcome back to the Rebuttal Podcast, where we break down case law, comedy, and of course, chaos in the legal field. I am your host, Reb Maisel, and today we learn the very important legal lesson that really only the smartest people in this field know, but I am going to share with you to make sure that you guys are smarter than a Tennessee judge. I know, crazy. What you say in a divorce proceeding, specifically when you are testifying under oath in a deposition, in a divorce proceeding, can and will be used against you in literally every other aspect of your life, including in a judicial election, an appointment, if you will, to the Supreme Court of your state. I know, write this down, take notes. I'm sure it will totally, absolutely apply to y'all who are in the quest for your judgeship, for your judicial appointment, for your tenure, for your run, okay? Tell your friends. Let's get into Nashville judge Kelvin Jones. Warning, this case has layers to it, okay? Layers meaning the hero of this story, who I'm about to quote, isn't actually a hero in real life, right? They're only a hero for purposes of this niche situation. And then you Google them and find out, oh, they were disbarred. We'll get to it, okay? Lawyers, let's clean it up. Let's tighten it up, all right? Lawyers and judges, let's tighten it up a bit, all right? Make it a little cuter, a little cleaner. Keep it cute, which also means 99% of the time keeping it mute. Thank you. Quote, "You have got an impressive slate of candidates," Brian Manookian said on December 8th, 2021, to a panel considering applications for a Tennessee Supreme Court seat. Judge Kelvin Jones is not one of them. Manookian gave a number of reasons for this, only one of which involved Jones's admission that he had buried $100,000 in his backyard to hide it from creditors. Judge, as of 2021, had been a judge in Davidson County, Tennessee since 2014. His wife filed for divorce, and Jones was deposed in that case in July 2020. As you might expect, many of the questions in that deposition had to do with financial matters, and many of Jones's answers were interesting, which is sometimes not a good thing for answers to be. Several of these answers involved the buried cash. This came up in connection with documents showing various large deposits, quote unquote, to a bank account, cash deposits totaling more than $190,000. The wife's lawyer was interested in learning where that cash came from and noted that in discovery responses, Judge Jones said only that it came from, quote, cash on hand, which is a roundabout way of saying, I'm not going to tell you. Doesn't tell us much, right? At first in the deposition, Jones did not seem entirely sure where the cash came from, right? Look, I have hundreds of thousands of dollars lying around as well. What can you do? But then recalled that he had kept about $100,000 in a CD, a certificate of deposit savings account, in various banks at various times, which he used for expenses related to investment property. He would withdraw a few thousand at a time when necessary. He said, why not just keep that in a regular account? They asked. Jones explained that, quote, in business, you don't want to have a lot of cash in accounts because the state at some point, if you're going to owe a bill for your hotel, can come in and garnish your account. Weirdly specific. So I didn't want to have that much cash in an account, end quote. Obsessed. Amazing. Perfect. Love it. I might not be an expert in finances, but I do believe that you're not allowed to withdraw at any time cash from a CD, okay? It's like the point of a CD is like, oh, it's going to be in there for a while. All right, for a minute. There are penalties to that, early withdrawals, if you will. And also, there is no law prohibiting a creditor or a state garnisher, debt collector from getting money, from collecting money forcibly from a CD. Like putting it in an account like that isn't protecting. You get it. But who am I? Whomst am I, right? Also, even if this explanation did make sense, Jones had testified that the value of the CD was only about half the amount of the mystery deposit. So again, we're back to square one. Where'd the money come from? Babes. Might there be another place from which he had dug up this cash? The lawyer asked. Turns out there was. His backyard. Quote, I bought one of those survivor tubs, Jones testified. It has a top that screws on, and it's insulated, waterproof. It is sealed. And that particular container had over $100,000 in it. And it was buried in the ground right outside of our master bedroom. The lawyer then followed up with some insightful questions about exactly how this worked. Now, mind you, I'm going to explain where the lawyer's going here with this, okay? They're going nowhere with it. But the idea is when witnesses in a deposition, the husband, right, the now soon-to-be ex-husband, is testifying and they out of kind of nowhere say something really bonkers, and you're like, what? Wait a minute. What? There's no like time for you to, in a professional way, get your bearings, I guess, and be like, okay, wait a minute. Let me think about this. Like, let me think about the next 20 questions I'm about to ask. Like, you're not like, okay, wait, can we time out for a second? Because you want to, listen, he just admitted to something insane. Let's keep this seat hot, all right? Like, let's keep going. So essentially, you're asking any question that comes to your head, that comes to mind. You just keep doing that until you can come up with like what the other half of your brain that's actually locked in somewhere with like thinking about how this relates to the case and how it's helpful to your client, or what we should ask more to get as much information out of this guy as possible until his lawyer or another lawyer or somebody else, or he realizes, hey, I should tells him to shut the hell up, okay, and never talk about this ever again, or just deny that he said it or deny that he admitted it. You want to get him talking about this for as long as possible, okay, until you can come up with something better to say. This is very obviously what this lawyer was doing. This is a perfect demonstration of you just got to keep it moving, keep them talking, keep them chatting, okay? In a deposition specifically. Question, what are those things called? Survivor tubs or something? Answer, yes. There's a name for it. It's a survivor. I don't know the exact name of it. Take a picture of it. But it's just plastic, durable plastic that's waterproof. It has a bag, plastic bag, and then just sort of question. So you just dig a big hole in the ground and you put it in? Answer, that's correct. Question, so when you put the money in or whatever you have in there, you just put dirt over it? Answer, that's correct. Question, how deep down do you put it? Answer, it's probably this tall. Question, do you put grass on top of it or put it in a flower bed? I'm just curious. Answer, you can put it whatever. I think the goal is to put it someplace that's close enough to your house. For me, it was right outside of the bedroom and it was not in the area. There was not grass there. So probably where dirt and grass didn't grow much. I didn't want the lawn folks to be cutting the grass and accidentally, be doing something and it just sort of become revealed. So it was just dirt over it, almost right up against the house. Question, so then did you take the whole container when you moved from Haley's Hope Court? Answer, yes. Question, where did you put it? Answer, we left Haley's Hope Court, brought it to the house, and actually I didn't bury it again. I actually put it inside of the gun safe. Question, is the gun safe? Answer, bolted to the ground in the garage. Question, is that the safe where you put this other money? Answer, that's correct. Question, okay. So is that where all the money came from when you did the deposits in that month last year, the month of May? Like, you see, we're having to catalog and process. We're processing, okay? The lawyer is processing. We don't actually need to know the process for burying this damn survivor tub. What we do need is to stall and to try to get some time in. All right. That happens in the deposition. Okay. And then we seemingly completely go to different topics, not necessarily completely different because we're talking about the money and blah, blah, blah. Okay. But about 60 or so pages later in the deposition, the issue of the burying the cash comes up again. God bless. All right. As it should. But it took 60 pages for the lawyer to be like, okay, processing, and it's processed. All right. Let's get back to it. The cash deposits and buried treasure issue resurfaced. It appears that the judge took out a big loan so he could invest in a hotel project. The hotel opened in 2008, right before the recession, and it failed a year or two later. The bank foreclosed, and the judge was left owing about $700,000. He testified that for years, he would try to settle the debt for some smaller amount, telling the bank he didn't have any money. According to one report, the bank was garnishing his judicial salary at the time. Finally, they said they would take $150,000, Jones testified, and we're back to the deposition. Jones, and I said, lawyer, let me go dig up that cash, ? Jones, I said, okay, that's a deal. As you can see, he did not admit to saying, let me go dig up the cash, quote unquote, possibly because he had been telling the bank he had no cash to dig up. Instead, he asked his father-in-law to write a check for $100,000, saying he would reimburse him in cash, and then, quote, shoved $50,000 into the bank within a really short period of time, making a number of relatively small and probably recently excavated cash deposits in order to do this. Why? Well, some unfinished sentences followed. Quote, this is Jones. I couldn't force a whole bunch of cash into the ... It just wouldn't have looked right to force a whole bunch of cash into the bank right away because then ... Lawyer certainly alerted me when I was looking through those documents. Jones. Well, it does, but it would have triggered all kinds of ... It wouldn't have been an issue. I could have explained it because I knew where the money came from, but ... One phrase he might have been thinking of there is, quote, money laundering, or more specifically, structuring financial transactions to evade reporting requirements, which is what the U.S. Code calls it. This is probably one reason the Tennessee Bureau of Investigation looked into the matter after that deposition essentially became public. Okay, it was public knowledge, it was filed on the record. And this one attorney, who I mentioned briefly in the beginning, his name is Brian Manookian, basically went on a spree, like sending all of, I guess, like the divorce papers and the deposition transcript and all this stuff, sending all this stuff to like every news org, Bureau of Investigation, the bar, like everybody in Tennessee, the whatever, like Judicial Oversight Committee, the whole thing, because this guy's still on the bench as a judge, basically saying like all of you need to investigate this guy because this is super sketchy. But not only that, okay, the burying the cash part of the deposition, you might be thinking, okay, like, so this guy buried some cash, like may or may not have been some evading, some kind of financial white collar type of crime situation. Who cares? Snooze fest, like dime a dozen, right? Well, he also admitted to like a lot of overtly illegal criminal conduct in the deposition, just on the record, just serving it on a platter to whoever would like to see it as literally an admission, a confession under oath, right? Like you are under oath. It's not even, it's better than a wiretap. It's better than overhearing it in public. It's better than even like saying it while you're on the bench, gabbing with some people while the court reporter is typing everything you say. Like this, you literally testifying under oath in a divorce proceeding. Yeah, that's tough, right? That's pretty tough. So yeah, not the only thing that he did. Let's go through what else was going down. Prior to and during the course of his divorce proceedings, Judge Jones has engaged in multiple criminal acts, unethical acts, and dishonest acts in violation of the Tennessee Code of Judicial Conduct. Those acts include the following. 1. Judge Jones criminally impersonated another divorce attorney by leaving a voicemail he intended to be discovered by and which was discovered by his then wife, Denise Jones. In that voicemail, Judge Jones claimed to be Greg Smith, the divorce attorney, calling for the purpose of confirming Attorney Smith's engagement by Judge Jones in Judge Jones's divorce case. In doing so, Judge Jones actually traveled to Greg Smith's law firm, that office, in Nashville, to place the call from a law firm office phone line in order to further the scheme of intimidating his then wife. So he was only doing this to intimidate, but like shock and awe to some people, you can't impersonate an attorney for the purpose of intimidating your wife. Especially in your, like while you're a judge, that is indeed unethical and dishonest. And there is a code of conduct that judges have to adhere to. Let's keep going. Judge Jones also criminally impersonated his own attorney, James King, in an effort to discover the identity of the man Judge Jones suspected of carrying on a relationship with his then wife. 3. Judge Jones criminally impersonated the assistant of his wife's then fling, Shun Sheffield, and Shun Sheffield's assistant in order to deceive a third-party business into sending Judge Jones financial documents belonging to and meant for Mr. Sheffield, the fling, that his wife was cheating on him with. In addition to constituting criminal impersonation, you can't do that, you cannot. Judge Jones' actions in this regard also constitute identity theft under Tennessee law. Impersonating someone for the purpose of getting their confidential sensitive documents, financial information, that is you can't. So shock and awe to some people, you can't do that. You can't do that. Oh my God. Number 4, Judge Jones claimed to represent he's just literally putting on a show. Like, be an actor, go to an acting class, your local improv station, all right? Act like some other people that aren't literal real people in real life in your divorce case, You could even write a play about all of these characters and people and form your own ending about how you were this amazing sleuth. You were able to just find out all this information by impersonating everybody and you never, got kicked off the bench or investigated for it. Like, you could totally do that, You can live in a fantasy land, all right? But unfortunately, none of us do. He really was impersonating the house of everybody. Always and forever. Love makes you do crazy things. I totally understand. She was probably a baddie, all right? Your wife then, but it's now ex-wife. Totally get it. But unfortunately, infidelity is not a crime. It is not. And you can indeed get divorced, and things can happen the way they're going to happen, okay? Sometimes when someone engages in infidelity, you can use that as evidence with respect to things that you want in divorce, things that you don't think that they deserve, blah, 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 blah. Okay, if there's a prenup involved with an infidelity clause, like, you get it. But, like, you can't be doing this. You can't. You cannot. I'm so sorry. I know. Tough. Anyways, he continues. Judge Jones claimed to represent a third-party witness in his divorce action and then further asserted attorney-client privilege over his communications with that third-party witness despite being barred from practicing law as a sitting judge. Yeah. Number 5, Judge Jones illegally accessed, reviewed, and forwarded himself dozens of emails from his wife's work email account, including statutorily confidential communications between his wife and her attorney while they were adversarial parties. Judge Jones then deleted the sent emails from his wife's account in an effort to conceal his conduct. Yikes. Number 6, Judge Jones undertook an intentional and long-standing pattern of conduct while he was a judge that was intended to deceive judgment creditors, who were, at the time, garnishing his judicial wages by engaging in illegal structuring, smurfing, money laundering, and burying over $100,000 in cash in his yard in an attempt to conceal assets that would otherwise have been properly seized by his creditors. He not only, in doing all of these things, all right, violated a bunch of codes of conduct, all right, with respect to being a judge, okay, about dishonesty and candor and trustworthiness and using your position to deceive others. He literally admitted to all of these things on the record in the deposition, okay? So, for example, question, did you impersonate, this is in the deposition, okay? Question, did you impersonate Greg Smith from Stites and Harbison on a voicemail? Answer, no. Oh, yes. Yes, yes, yes. To get his mail. And then I did go into the little phone there and I called the house. I said, Greg Smith, looking forward to working with you, Mr. Jones. Question, so you called from Greg Smith's office? Answer, not from the office, from the lobby. When JJ went up to check the mail. Question, from that firm? Answer, I was waiting for him. I just went up to the phone there in the lobby and left me a message, like our house phone a message. Perfect. With respect to the impersonation of his wife's Mr. and the Mr.'s assistant, okay? This is what he said. And this is Jones talking, okay? This is him talking and quoting how the conversation went when he was impersonating his wife's Mr. Get a kick out of this. Quote unquote, get a kick out of this. Hey, this is Shun Sheffield. Was rushing checking out yesterday. Can you send me a copy of my portfolio for my stay? Sure thing, Mr. Sheffield. Hold on one second. When did you check out? Last night. Okay. Or yesterday. So yeah, where do you want me to send it? Sent me the portfolio. That's how it happened. Just like that. And for them, I said, this is Shun Sheffield's assistant. Can you send me this stuff? Because they said, you want it sent to the email on file? I said, no, send it to me. So they sent it to me. Question, so you impersonated Shun Sheffield's assistant? Answer, I was his assistant. No, you weren't, babe. No, you weren't. The rest of it literally goes like that. With respect to every allegation of misconduct and illegal activity that I just laid out for you, there is a place in the deposition where he basically goes, yeah, I did it. Thank you so much for asking. And the lawyer asking the questions was probably like, this is so perfect. Thank you so much. Okay, perfect. So in the face of investigations, a divorce that he's definitely losing, and everyone in the public knowing that his days on the bench are probably numbered, he responds by applying for a seat on the state Supreme Court, as one does. Jones did that in September of 2020, along with several others who applied after a sitting justice died. The application included that pesky question, quote, are you now under federal, state, or local investigation for possible violation of a criminal statute or disciplinary rule? And Jones did not answer yes, which is perjury. It's a lie. Okay, you lied. You can't lie on an application such as that. He did acknowledge the investigations, though, saying they were prompted by Brian Manookian, that random lawyer who hates him, who Jones described as an oft-suspended attorney. Manookian, who we're about to talk about in a second, complete aside, has indeed been suspended apparently twice. So a spade can call a spade, apparently. Pot and kettle. They can talk to each other and they can name each other. Great to know that that's still an occurrence. Jones was reportedly, quote, nonchalant about all of this at the December 8th meeting, where the panel had a few questions about his backyard pot of gold at the state Supreme Court application panel. Okay, 2021. Quote, it may seem strange, Jones told the panel, but I'm from Alabama. Please, go on. Quote, we keep money in mattresses, mason jars, and other places, particularly when you don't get a significant rate of return from banks. Look, if you're from Alabama, if this is something that people do, I am not knocking ya, all right? I don't presume to give anyone financial advice. You do whatever you want to do, whatever you typically do, whatever pirates do. That's totally your prerogative. I am not making fun of people who do that for this. I am simply maybe planting the seed that the rate of return from a hole in the ground being 0% is not the biggest issue here. Doing all of that while you have creditors and wage garnishers on your back, and then lying to everyone about how much money you have and basically not disclosing where that money is or where it literally came from. So those might be bad things, right? That might not be legally sound, I fear. But that's not legal advice, as nothing in this podcast is. Kisses. In 2022, okay, about 6 months after he, spoiler alert, didn't get a seat on the Supreme Court, I know, crazy, a judge, another Nashville judge, with respect in relation to his divorce proceedings, held in an order that Judge Kelvin Jones did indeed act illegally during contentious divorce proceedings. Because of that, but not really because of it, but like part of that, all right, definitely went into the ultimate holding the judge issued, which was denying Jones's attempts to reverse the initial judgment in the divorce. He, of course, has vehemently denied any illegal activity, including after this order was issued. The Tennessee Bureau of Investigations was asked to help in the investigation, like the criminal investigation of Judge Kelvin Jones in relation to his illegal conduct during his divorce proceedings. That all happened in 2021, 2022, okay? There is like no update with respect to that I could find, okay? Did I look that hard? Not really. If you find something, let me know. But what I can tell you is that he's not a judge anymore. All right. He's not a judge anymore. I do not believe he ever had any criminal charges filed against him in relation to that conduct, okay, including the $100,000 buried in the yard. If you can find something that proves me wrong, let me know. But all I can see is that he still practices law as part of a law firm in Tennessee. And, you know, if the worst that comes out of it is, you know, a divorce that didn't work out great for him and that we know he's from Alabama, I guess that's just how the cookie crumbles. Then he got off pretty easily, don't you think? I would agree. You can see why that could be concerning, but I'm actually going to point your attention to a random character that you probably thought would not be important and really isn't. He was the attorney, Brian Manookian, who in the very beginning said, "You've got an impressive slate of candidates. Judge Kelvin Jones is not one of them." I mean, zinger, right? Period. Absolutely. Mic drop. You're doing amazing, except he's not doing amazing. Not so much. In completely unrelated news, in 2024, okay, this is what came up when I Googled his name, just to see, like, how does he really relate to this case? Maybe he's just a vigilante, not even vigilante, I guess. Maybe he's just like the Robin Hood, right? Like making sure that everyone is getting their just desserts, all right? No, Judge Jones is a liar and a cheat and did bad things during his divorce. Look at this deposition. He was the one who was emailing all these news organizations and like investigation bureaus of investigation and the bar and everything, saying, hey, you should investigate Jones for all of these criminal things. And it was actually like a very, you know, well-written letter, really teeing everything up really nicely, highlighting pages in the deposition that were relevant. Yeah, he should have been minding his own damn business, unfortunately, I fear. Not every whistleblower doesn't also have a whistle about to be blown in their face. Write that one down, or not. Either way. What I am reading from is a press release from the Tennessee courts issued February 16th, 2024. Quote, "The Tennessee Supreme Court today reversed the decision of a Tennessee Board of Professional Responsibility hearing panel suspending the law license of Nashville attorney Brian Manookian and instead permanently disbarred him." Now, mind you, imagine you hear the ruling of the Board of Professional Responsibility, okay? The board that oversees attorneys and misconduct and all of that. And you hear that they're like, "Oh, we're suspending you for what you've done." And you go, "Damn it, that's so wrong. I'm appealing." And the holding of the Supreme Court is, "Oh, period. So we're actually going to reverse because they didn't go hard enough. They didn't hit you with enough force. Oh, they wanted to suspend you? Nah, you're actually done. You're done for life. Sorry. Permanent. Temporary? You thought that was unfair? Guess what? They actually should have hit you again." That is so embarrassing. Y'all, sometimes you need to just lay down and take the punishment. Oh my God. So let's hear. Let's hear what he did, shall we? Because we're nosy. Perfect. The court held that after Mr. Manookian's continuing serious violations of multiple rules of professional conduct, even after he had received several sanctions and suspensions, disbarment was the only appropriate action. In 2016, Mr. Manookian represented a plaintiff in a case in Nashville. An opposing lawyer in that case, who had fired Mr. Manookian from his law firm years earlier, sent him a letter criticizing his discovery responses. Mr. Manookian sent the lawyer an email with false, unflattering statements about the lawyer's grown daughter. The email said Mr. Manookian had close friends at the daughter's new employer and he would, quote, make it a point to influence the daughter's future there. The lawyer saw this as a threat and asked the trial judge to sanction Mr. Manookian. In response, Mr. Manookian publicly filed a document that discussed another lawsuit where Mr. Manookian had represented the lawyer's son on a sensitive matter resolved years earlier in a way that was inaccurate and intended to embarrass the son. The trial judge sanctioned Mr. Manookian. In response, Mr. Manookian tried to have the judge disqualified by making false and unsubstantiated claims about the judge. After a second lawyer opposed the disqualification, Mr. Manookian sent the second lawyer a series of emails, often copying more than a dozen people, that attacked the lawyer's reputation, made false allegations, and embarrassed him. This went on for several months, with the second lawyer moving for sanctions multiple times and Mr. Manookian responding by escalating his attacks. In an effort to intimidate the lawyer, Mr. Manookian used a paid computer tracking application to get detailed private information about the lawyer and his family, and then used a second paid investigative service to find even more. Girl. He then sent an email to the lawyer and others reciting private information such as how many times the lawyer had opened one of Mr. Manookian's embarrassing emails, the home address where he was opening his emails, and details about the lawyer's home, his wife, his children, his marital history, and a description and location of his wife's car. Okay, psycho. Mr. Manookian's conduct was reported to the Tennessee's Board of Professional Responsibility for violation of Tennessee's rules of professional conduct, ethical rules that all attorneys in the state must follow to maintain their license to practice law. A hearing panel had a hearing where the board asked the panel to disbar Mr. Manookian. In the hearing, Mr. Manookian claimed legitimate reasons for his conduct. The panel did not find him credible. After reviewing evidence and testimony, it concluded his only purpose was to intimidate and humiliate the opposing lawyers and threaten the well-being of their families as an effort to gain unfair and unethical advantage in the case. The hearing panel found Mr. Manookian violated multiple ethics rules and determined its guidelines showed he should be disbarred. But without giving a reason, the panel recommended a 2-year suspension instead of disbarment. Mr. Manookian appealed to the Chancery Court, where the board again asked for disbarment. The Chancery Court agreed Mr. Manookian should be disbarred, but it affirmed the suspension because of procedural rules that required the board to file a separate appeal. Both Mr. Manookian and the board appealed to the Tennessee Supreme Court, where the board asked the court to disbar Mr. Manookian. He claimed the court could not disbar him because of the procedural rules cited by the Chancery Court. Majority of the court rejected this argument. It agreed the procedural rule limited the lower court's authority to impose a different sanction, but it cited numerous authorities that give the Supreme Court broad authority to review all attorney discipline. The court held the rule did not limit the court's authority or its responsibility to determine whether a lawyer should be disbarred. The majority of the court held Mr. Manookian violated multiple rules of professional conduct and rejected his argument that his actions were protected by the First Amendment. So, yeah, they said, quote, our rule as guardians of the public trust requires us to impose disbarment. So the court ordered Mr. Manookian disbarred from the practice of law in Tennessee, period, forever. So I'm sorry, Brian Manookian, you are out. The other guy, formerly Judge Jones, is still in that he practices law. But hey, we're all people here, regular people who make crazy mistakes, and sometimes we're also lawyers. My rebuttal for today's episode is to make sure if you do bury money, hundreds of thousands of dollars specifically, in your backyard, you put a beautiful flower garden over it, because why not make it pretty when it's inevitably found out and you inevitably admit to it in a divorce proceeding? But also, maybe this is a commentary on marriage, right? Get a prenup and include money buried in the backyard. Listen, I'm out of jokes for today. Love you guys. See you next time. This has been an episode of Rebuttal. Bye.